A very warm welcome to the IUCN World Commission on Environmental Law's Environment Webinar Week. The Environment Webinar Week is a 5-day webinar series to explore contemporary current challenges in international environmental law and of course also discuss possible solutions. The International Union for the Conservation of Nature's World Commission on Environmental Law is one of the 6 expert commissions of the IUCN. We have a worldwide membership and we work primarily through the specialist groups. And this webinar today is organized by the WCL Climate Change Specialist Group. The aim of the World Commission on Environmental Law is to advance environmental law, capacity, knowledge, expertise around the globe. And please check out our program of work at our website at IUCN WCEL. My name is Christina Voigt. I'm a professor of law at the University of Oslo, and I'm the chair of the IUCN WCL's Climate Change Specialist Group. The 5-day webinar series is the WCL's run-up to the 2021 World Environment Day on 5th of June this year. And we started our series yesterday with a webinar that looked back at the legacy of the Stockholm Declaration and the codification of environmental principles in the last almost 50 years. Today, we will look at climate change law and the dynamics between climate change legislation and litigation. I'll say a little bit more about this in a second. Tomorrow on Wednesday, we will continue with our 3rd webinar in our series where we look at developing effective strategies for environmental compliance and enforcement. On Thursday, the 3rd of June at 5 p.m. European time, we will turn to the law of the sea and look at the United Nations Convention on the Law of the Sea as a living instrument to address or to provide solutions for the 21st century. And finally, on Friday, 4th of June at 7 p.m. CST, we wrap up with looking at biodiversity and the law. We have invited leading experts in the respective fields to discuss with us and the audience, of course, these topics. If you're not able to follow all of these webinars, you will find recordings of them at our website, which will be published in due course. And before we turn to today's webinar, please let me address some housekeeping issues. First of all, we have simultaneous interpretations in 3 languages, in French, English, and Spanish, and you can choose the respective language at the interpretation bottom at the bottom of your page. Also, please post your questions in the Q&A box throughout the webinar. We will attempt to put them to the panelists towards the end of today's session. And finally, I would like to thank the WCL's executive officer, Emily Gaskin, for the technical support and the preparation of this webinar, and of course also to the chair of the World Commission on Environmental Law, Justice Antonio Benjamin. Let me turn to today's topic, climate change and the law, dynamics between climate legislation and litigation. Well, the science is clear on what needs to be done to address climate change. In order to meet the temperature goals of the Paris Agreement, to hold temperature increases to well below 2 degrees and to pursue efforts to keeping them at 1.5 degrees Celsius, pathways of emission reductions will need to be around 45% by 2030, and leading to net zero CO2 emissions around 2050 and staying negative thereafter, according to the IPCC, the Intergovernmental Panel on Climate Change. Now, in order to achieve this goal, science has to be translated into concrete policies and actions and measures. And this is where the law comes in. Law as an important lever to translate these international goals and the science into action and behavioral changes on the ground. Many states are currently adopting national implementation measures, national climate acts, revising their regulation in particular sectors or overall. But at the same time, we also see an increasing trend of climate litigation all over the globe. It's almost so fast that you haven't even finished reading one judgment before the next one is being released somewhere else in the world. So what we're seeing is that citizens and organizations, non-governmental organizations, are bringing claims against governments and private actors, private corporations, to court for insufficient action on climate change, amongst other things. But what is the relationship? And that's the topic we would like to discuss today. What is the relationship between climate law making and climate law speaking by the courts? We will address questions like, is it the role of the lawmaker to make law? And what is the role of courts in this situation? We have ample evidence of courts giving concrete guidance and requests to states and to corporate actors. And what we see is where there are concrete rights and duties at stake, courts, not all, but many, assume their legitimate role of judicial review and of dispute resolution. And why shouldn't they? As the third pillar of power, the role of law ascribed to them, the function of controlling government power in accordance with the law, is an important element of the rule of law. But second, more intricate, is the dynamics between enacted climate laws and regulations on the one hand and litigation on the other hand. Here the question could be posed, do we see climate litigations where governments have no laws or acts or regulations? Do these cases focus on omissions of acts of governments? For example, that they're not acting in accordance with their constitutional norms. For example, this was the case in the in the first constitutional complaint brought against the government of Germany, which was addressing the absence of a climate act. Only later on, the Climate Protection Act was adopted, but the first constitutional complaint, which led to the decision by the German Constitutional Court, which was issued about a month ago, that was addressing the omission of governmental action. Or do we see climate litigation because of climate legislation, because we have climate acts, but they are not clear enough, or not ambitious enough, or not fair enough? We have the case, for example, of Friends of the Irish Environment against the government of Ireland from 2020, where the Supreme Court of Ireland quashed the national mitigation plan because that plan violated Ireland's Climate Action and Low Carbon Development Act, because it wasn't clear enough, it wasn't specific enough to implement that act. Or again, the decision by the German Federal Constitutional Court, which I just mentioned, which requested, by the way, Germany's highest court, which requested about a month ago the government to revise its Federal Climate Protection Act because it put an undue burden on the young people who will have to implement it, and where in the time frame from 2030 to 2050, no concrete action were included in that act in order to achieve carbon neutrality by 2050. And that was considered to violate constitutional freedom rights of those young complainants. And the question is, would we not have those cases if we had not those acts? Finally, do we see litigation based on new and innovative legal arguments and reasoning, for example, to test new grounds, because climate change is a new and unprecedented challenge that many courts did not have to consider until now? For example, the recently decided case in the Netherlands by the District Court in The Hague against Dutch Royal Shell was ordered or the company was ordered to reduce its emissions by 45% in 2030. And that was based on an unwritten duty of care in the Dutch civil code. And in interpreting that unwritten duty of care, the court, in an unprecedented manner, took into account international law, international human rights law, and soft law under international law that was, to start with, not binding on the private actor. What we see, and that's what I tried to sketch out in that brief introduction, what we see is a fascinating interplay between the law in the books and the law in the dock, between the written and the spoken law, between legislation and litigation. And this is what we are all looking forward to discussing with our panelists today. And it is with great pleasure to introduce at this moment our moderator for today's session, Dr. Francesco Sindico. Francesco is a dear friend and good colleague of mine for many, many years by now. Francesco is a reader in international environmental law at the University of Strathclyde in Glasgow at the law school. He is also the program director of the Strathclyde LLM in Global Environmental Law and Governance. He has established the Strathclyde Center for Environmental Law and Governance and is now its co-director. He also is the founder and director of the Climate Change Litigation Initiative, which, as far as I understand, will be launched at COP26 in Glasgow. And together with Makanu Genge, who we heard yesterday, he edited the book Comparative Climate Change Litigation Beyond the Usual Suspects. And he also recently published a monography on international law and transboundary aquifers. Francesco works across the large spectrum of environmental law, and he's passionate, I think it's fair to say, he is passionate advocate of environmental law and the role of environmental law. And that also beyond the usual suspects, because he is involved in One Ocean Hub and Island Explorers, which are programs that are aimed beyond lawyers, even at primary schools, to educate young people about the role of the law. And he does that all in English, Spanish, Italian, and French. What more to say? Francesco, we're happy to have you here today, and I pass the floor to you.
Thank you. Thank you so much, Christina. But I will only do it in English today. I have way too much respect for translators, and I think it's better for everybody if I just stick to English. Thanks for your kind words. And as you said, today the webinar comes in the wake of yet another week with big news from the climate change litigation front. We have seen scenes of plaintiffs frantically hugging themselves and literally jumping up and down in happiness. As you said, a court in The Hague in the Netherlands had said that not a state, but a private actor is under a legal obligation to reduce its greenhouse gas emissions. And not only direct emissions stemming from its refineries and such, but also from its consumers. And using 2019 as a benchmark, Shell has to reduce its emissions by 45% by 2030. The week before, the German Constitutional Court had issued another groundbreaking decision inviting the government to do more when it comes to climate change mitigation. Now, while this webinar will not focus on these two cases, although I'm quite sure that some of the speakers will be mentioning them, they do provide a timely backdrop to the focus of this webinar, which is, as Christina mentioned, the relationship, the interplay between litigation and legislation when it comes to climate change. Now, throughout the webinar, we will explore this relationship not by means of formal presentations, but through a conversation focused on 4 different points. First, we will discuss the extent to which having or not having climate change legislation will lead to more or less litigation. And we will consider what kind of climate legislation may be needed. Second, we will consider the extent to which enshrining human rights in constitutions and national legislation provides fertile ground for climate change litigation. Third, we will explore some recent developments when it comes to climate change legislation and what these developments may mean for climate litigation. Fourth, and finally, we will explore the extent to which strong climate change legislation may frustrate investors and lead them to seek redress through international courts. And to do this, we have 5 distinguished speakers who I will now briefly present. In alphabetical order of their surnames, we have Lord Robert Carnwath, former justice at the UK Supreme Court, and currently, amongst other roles, visiting professor in practice at the LSE Grantham Research Centre for Climate Change and the Environment. We then have Professor Marie-Claire Cordonnier-Seger, Leverhulme Professor at the University of Cambridge, Senior Director of the Centre for International Sustainable Development Law, and Executive Secretary of the COP26 Climate Law and Governance Initiative. Our third speaker is Ms. Sarah Mead, Legal Associate at Climate Litigation Network Uganda. We are then joined by Professor Michael Melling, Deputy Director of the MIT Center for Energy and Environmental Policy Research and Professor of Practice at the University of Strathclyde Law School. Last, but definitely not least, we have Professor Pilar Moraga, Professor at the Center for Environmental Law of the University of Chile. Now, let me conclude my brief introduction by going back to yesterday's brilliant first IUCN World Commission on Environmental Law webinar on the 1972 Stockholm Conference and the development of binding global principles of environmental protection. Even though the topic was not climate change litigation, the latter creeped in several of the speakers' comments. Climate change litigation has become mainstream, and a better understanding of its interplay with legislation will be a key facet both of research and practice in the foreseeable future. Now, the way the webinar will work is that I will pose a question to one of our speakers, and then 2 other speakers will be asked to expand on the question and comment on any point raised by the first speaker. And he or she will then conclude the segment with some last words, that being the first speaker. We will do this for 5 questions, and we will then move to the Q&A session. Let me remind you to use the Q&A box on Zoom to ask your questions throughout the webinar. In other words, feel free to ask your questions while you're enjoying the conversation with our speakers. So let's begin. I would like to start by bringing in Robert and by exploring one possible aspect of the relationship between climate legislation and climate litigation. Robert, do you think having a national piece of legislation on climate change, a climate change act of sorts, will lead to more or less litigation?
Welcome everyone. Can I start with an apology? I'm afraid I couldn't get my laptop to work effectively. I'm currently in Portugal on holiday, and my wife came to the aid with her Zoom on her mobile phone, so forgive the slight difference of style. I'm very glad to be asked to join this important group, and I was very interested by Christina's introduction because I think she's in a way put her finger on most of the points. I'd like to start, I think, by saying that we want to look at litigation rather more specifically. I mean, there's been a mass of litigation around the world over the last few years, documented by the Grantham Institute, among others. But I think one really should be focusing on what I would call effective litigation, that is, a litigation that actually achieves something. And I think the link with legislation is very important. If one looks at the sort of cases where there's been some success, then generally one finds a legislative hook to hang the litigation on. I mean, as a judge, reviewing these decisions and many of them are very intricate with a great deal of learning. And of course, they come from different legal systems. But I'm always to see what particular legal hook there is to hang the litigation on. I think Christina sensibly mentioned the Irish case, where you had legislation, but what the court found was it didn't really deal adequately with the specificity of the plans that were necessary to give it effect. And so the legislation provided a hook to hang that on. The German constitutional case, which she also mentioned, I think there was certain legislation, but it didn't go far enough. And I think what the court was saying was it doesn't really deal at all adequately with what's going to happen after 2030 and with the effect on future generations. So again, I think there was a sort of legislative hook. Going back in time, the Leghari case from Pakistan in 2015, there was no specific legislation, but there was the constitution, and a very Judge Mansur Ali Khan was able to use that to achieve something really effective in that particular context. Now, I think if there's no legislative hook, then I think there are problems about getting litigation off the ground. I think that the Juliana case in America was very disappointing in the end, but actually one of the problems there was there wasn't really any legislative framework within either in the American Constitution or federally for which to give that a basis. Now, so to some extent, I think, to answer your question, I think the legislation can and often does provide a basis for litigation. I think it also good legislation may reduce it. I think in this country, we'll come back, I've no doubt, to the UK Climate Change Act, but I think for reasons we may come to, it has so far been very effective in meeting people's needs, and that there's been little litigation, and such litigations there's been based on it hasn't got very far. That may, of course, change if the government doesn't live up to those commitments. So I'm afraid that's not a very precise answer, but I think, generally speaking, I think legislation can be important in providing a basis for effective litigation.
Thank you very much, Robert. I'd like to bring in Marie-Claire and Sarah in turn. Robert talked about a hook. How do you react to this? And what are your points, Marie-Claire, on this first question?
Thank you as well for organizing this fascinating dialogue as we come up to the next steps of this seminar series leading to World Environment Day this Saturday. And it is lovely to be involved with my friends. There is background noise. I would ask mute wherever possible to help with that. Just briefly on this question, I quite agree with Robert. I think that the legislation we put in place needs to be crafted in such a way that it allows for proper review by tribunals of judges. And I think that in particular, the legislation that we put in place needs to be carefully integrated with the legal system of the country adopting it. And here I just want to make two additional points to Robert's analysis. The first one is that, of course, when we think of climate legislation, and I have colleagues who are currently tracking over 1,400 climate acts at different levels of municipal or provincial, cantonal, state, or national, and I applaud them for their work. But we also need to look at how the legislation fits with thousands more pieces of regulation that relate to energy, forests, land and agriculture, that relate to early warning and assessment systems or disaster risk reduction, or how to evacuate people in a way that respects their human rights, or that relate to investment, trade, and insurance, or even our taxation regimes. And there also we are starting to find carefully crafted climate provisions. I see that as a very important positive. Yes, there may be more litigation, particularly in a few countries where litigation is very much the go-to way to resolve a problem. But more importantly, there will be a framework in place which helps the actors who negotiate in the shadow of the law to understand the legitimate expectations that should shape their decision-making, assuming that most people, most of the time, would like to try to be in compliance with the law. And here I would mention only 2 tiny points because I know time is short. When I was senior leader of the International Development Law Organization's Sustainable Economic Development Bureau, we assisted many countries through our Legal Preparedness for Climate Change initiative with the drafting of new regulations. And our first thought was not, how is this going to lead to litigation in the country in question? And in many countries, it really didn't have to do with what a judge would decide in the end. It had to do with what the investors would decide, what the people who had no jobs would decide, what the young people would decide, what would shape the relationships in the society, and how legitimate would the law appear to be. Our first question had to be, what is the existing regulatory framework, and how can we tweak it so that it will better meet our climate objectives? And that's where I come to my second and final point. According to our recent study, 167 of 186 nationally determined contributions under the Paris Agreement and the UN Framework Convention on Climate Change are requiring and planning on explicit legal, regulatory, institutional reform. So I don't think we even need to ask anymore, why or whether we are going to have national legislation on climate change. I think rather we need to ask, how can we make it the most effective possible? Thank you.
Thank you very much, Mary Claire. Sarah, so moving back to the overall question and any points that both Robert and Mary Claire put, I mean, what is your position when you think of a national piece of climate change legislation? Will it lead to more or less litigation? What is your short point? And then we can expand in further questions.
Yeah, thank you, Francesco, and thank you, Robert and Marie. I think it's fair to conclude that more legislation will likely be matched by more litigation, and Robert spoke of the legal hook sort of effect of that legislation for litigation. But it's important to note, I think, that climate litigation isn't dependent on there being climate legislation in place. And that was a question posed by Christina at the outset of this webinar. This is clear from the Urgenda case, which was brought in the absence of a climate act like the sort that we're seeing being passed throughout various European jurisdictions or various jurisdictions around the world at the moment. And at the Climate Litigation Network, which is a project of Urgenda where I work, we focus specifically on systemic mitigation cases, so cases brought to challenge states' overall mitigation efforts. In relation to this kind of litigation, the determining factor for whether or not there will be more litigation or any litigation is the level of ambition of states. And if states set climate policies that are inconsistent with their human rights obligations or other legal duties, then litigation can be expected to follow with or without a climate act. And a few other points worth mentioning just briefly. Often cases that are brought in relation to climate legislation are also brought in reliance on other legal duties on the state. So for instance, human rights law or tort law. And we see this in the recent German case, which has already been referred to, the L'Affaire du Siècle case in France, and also the South Korean and Ontarian, the cases in Ontario. Secondly, while some countries have adopted climate legislation, those acts might actually seek to exclude litigation. And that's also the case in my country, home country, New Zealand. But this only operates to exclude certain legal actions
such as perhaps administrative review, it does not make the state immune from legal action on the basis of other legal duties, specifically often human rights. Finally, I'll simply highlight that another aspect of the relationship between climate legislation and litigation is the role that climate litigation can play in actually strengthening legislation. And we have seen that in the Irish climate case. In fact, even after the unsuccessful High Court decision, I think it's fair to say that the case contributed to a change in the political context in Ireland, which led to a significant strengthening of the Irish climate legislation, which is, I understand, still underway. But then we'll also likely see the same effect in Germany. The successful case there, the government has already indicated that it will strengthen its ambition significantly. So I'll leave it at that. And we can come back to any of those points later.
Thank you, Sarah. So we're going to move to the second question, but this already shows how rich the tapestry of the relationship between legislation and litigation clearly is. But some of you mentioned good legislation, effective legislation. So let me ask a question to Michael here. What are the key features that a climate act needs to have in order to be litigation proof? So Michael, I know it's a tricky question, but that's what we're here for. How would you answer that question?
Thanks, Francesco, and of course, thanks for having me in this very illustrious panel. So it's really a relevant question. It's not just a theoretical question. How to make climate legislation that does not, let's say, incite or invite litigation against the state. I say it is practically relevant because that was exactly the question I was faced with when I was advising a Central Asian government on the prospects of climate legislation and the pros and cons of doing so. This was really a central concern of the government. Are we opening a weak flank if we adopt climate legislation, that we might be sued for not doing enough to meet the objectives of that law? So if I were to advise sort of a devil's advocate case, that luckily was not my mandate then, but if I were to advise a government now on how to enact legislation that is as litigation proof as possible, at the time, I might have suggested keeping it relatively vague, maybe very short, like for instance, the Japanese Climate Act of 1998, which has really sort of left the government a lot of discretion. It formulated more aspirational goals with a very short early generation of Scandinavian climate acts, which again, were not terribly specific. Or as Sarah mentioned, including a provision that actually explicitly limits the scope of judicial or administrative review, as she pointed to legislation in New Zealand doing. But I think recent years have shown us that that might actually be a very risky strategy, because litigation is not only being brought, as say in Ireland, for failure to meet the requirements, the obligations under legislation by the executive branch, but we actually have litigation against both the executive and the legislative branch under human rights obligations, say as in Urgenda, or as in the German case under the German constitution. I think that the German case is particularly instructive in how it shows, how it argued, the argument it made, that it's not just about ensuring that current obligations are met, but it also took this dynamic perspective looking at the distribution of burdens of climate action, so the cost of acting against climate change over time, and whether or not delaying or deferring action in the near term will increase the burden on not future generations, but sort of on the current generation in the future, and thus constrain their constitutionally guaranteed civil liberties in an unacceptable way. And so to me, that suggests that to really be litigation proof, also not just under the legislation as such, but also obligations like human rights or constitutional provisions, really what has to happen is, it makes probably the safest way to do so is to spell out the trajectory of reductions in the law from the outset, make it very clear how the government is planning to, how the state will reduce emissions over time. Ideally, even front load the effort, because as we know, delaying action will in fact make it even costly to achieve the same net zero emissions targets, for instance. So the sooner action is taken, the less we roll over increasing costs to ourselves in the future and potentially future generations where these may be protected. And I think an also important consideration here is many climate laws invite, an executive body or even an advisory body to help define the future reduction trajectory. That to me seems also increasingly risky. Again, in the German case, for instance, it was implicitly stated this has to be done through the formal legislative process. It is so central, so critical that it has to be done in the through statutory law itself. So for instance, the European climate law, which defers some of the future definition of reduction effort to the European Commission, an executive body, may be vulnerable in that regard. So ironically, to close it all out, the US actually had, so the closest the US ever got to climate legislation during the first term of President Barack Obama was the Waxman-Markey Act, or the American Climate and Energy Security Act that many might remember, passed the House of Representatives in 2009. And it actually contained a climate emissions budget for every year between 2012 and 2050. That to me seems, if it is sufficiently ambitious and doesn't backload effort, pretty much the only foolproof way to enact legislation without risking litigation.
Thank you so much, Michael. I do remember wading my way through hundreds of pages of the Waxman-Markey draft back in the days. So let me bring in Robert and Pilar this time. Robert, I think you already hinted that you wanted to bring in a little bit of the UK dimension here. So maybe I give the floor to you immediately about what does it look for a climate act to be litigation proof, and what are your thoughts on a good climate act?
Well, I don't think anything's litigation proof, but I think the UK Act has, it's a remarkable act. It's one of the first, 2008. And I think there are two key features about it which is worth emphasizing. The first is the statutory involvement of an independent statutory advisory group, which the Climate Change Committee, I think, has proved itself pretty effective. And what is important is not that it's actually built into the system, that it makes its proposals, and the government then has to take a view on them and a reason. And we're waiting at the moment for the response to the sixth program. But I think that is very important, because it means that any litigation, any judge looking at it is going to be guided very much by how what the government's doing relates to the independence advice is getting. And I would have thought that litigation is not going to get very far so long as the advisory committee is supporting the government. And of course, the other thing related to that is that it does look forward. I don't think one needs to go as far as having a sort of set out now the budget for every year until 2050 or whatever. But what I think the UK one does is to take us forward by 6-year periods, so that we're now looking at the budget for the period up to 2038. And so it rolls forward. The budget has to be set, I think it's 12 years ahead. And I think that's a very important feature. And so I think when we're looking at the qualities of legislation, the sort of features of the Climate Change Act 2008 are a pretty good starting point.
Thank you very much, Robert. Pilar, can I bring you in here? So we have asked Michael, what are the features of a climate act that are litigation proof? Robert said there is no such thing. He started out like that, which I to some extent fully agree. What is your stand here, Pilar, on this question?
Gracias, Francesco. En mi caso voy a hablar en español. Espero hacerlo lentamente para la traducción. Quería dar algunas ideas preliminares respecto de lo que es una ley especial de cambio climático. La verdad es que vemos que hay una gran variedad de tipos de leyes de cambio climático. En el caso chileno se está discutiendo un proyecto en este minuto que tiene por principal función atribuir responsabilidades a los distintos órganos del Estado y establecer instrumentos de gestión para el cambio climático con una meta muy clara, que es la carbono neutralidad al 2050. Ahora, esto no necesariamente va a favorecer la litigación climática. Y en ese sentido, creo que hoy en día la litigación climática nos demuestra que son las normas de carácter más bien general, la Constitución o normas, incluso el Código Civil, que son fundamentos del litigio climático. Pero la litigación climática se enfrenta a los propios limitaciones de categorías tradicionales del derecho. Es muy difícil probar la causalidad, es muy difícil entregar prueba o demostrar un interés directo. En este sentido, creo que la jurisprudencia ha hecho un gran esfuerzo por interpretar de manera amplia la legislación actual para reconocer justamente y dar lugar a la litigación climática. Y como me queda muy poco tiempo, quisiera en este sentido quizás dar una vía concreta que puede favorecer la litigación climática, como son las acciones populares. Porque uno de los principales problemas en la litigación climática es justamente demostrar el interés individual que puede existir en la acción, y justamente el cambio climático nos llama a proteger estos intereses colectivos de comunidades o grupos que se pueden ver enfrentadas a los impactos del cambio climático. Gracias, Francesco.
Thank you very much, Pilar. You really hit the nail there. There are so many problems with direct interest, and it comes with standing, it comes during the actual case. So thank you so much for that. I'd like to now move to the third question that we have discussed. This is, however, the second point that I raised in my introduction, and it's a human rights aspect. And I'd like to bring in Sarah here. I was wondering, maybe looking at some recent trends. As Christina said, there's one every day. She mentioned, I mentioned the Shell case, she mentioned the German, but you can go as far away as Guyana, as Uganda. There are literally climate cases propping up everywhere. So when and how do you think, Sarah, human rights provisions in legislation and national constitutions provide a solid ground for domestic litigation?
Yeah, thank you to Francesco. And you're indeed right. Human rights provisions in legislation and constitutions are proving to be an increasingly solid ground for domestic litigation. We're seeing more and more cases being brought based on human rights. And that's been particularly the case since the success of the Urgenda case, which led the Dutch government to being ordered to reduce its emissions on the basis of its human rights obligations under the European Convention of Human Rights. And we've seen a real upswing in these cases since. From our perspective, this should really come as no surprise. Michelle Bachelet, the UN High Commissioner for Human Rights, has described climate change as something that the world has never seen a threat to human rights of this scope. So given that most countries have protection for human rights, either in their constitution, under a regional treaty, or in plain legislation, it would be strange and maybe even quite troubling if human rights law wasn't kicking into gear at this point of the climate crisis. In terms of how human rights are used in these climate cases, it really depends on the jurisdiction. They are relied on either directly. So we see that in the Urgenda case, the claimants relied directly on the European Convention of Human Rights, which is accorded constitutional status under the Dutch Constitution. Or in South Korea, where the youth plaintiffs have relied directly on the constitutional rights, right to life, healthy environment, and equality, to challenge both the Act itself, the Climate Act, and the targets set pursuant to it. And then we also see human rights kind of operating indirectly. So where a claim is being brought under tort law, we have seen the court drawing on human rights law to inform the standard that's applicable in that case. And that was the case in the district court judgment of Urgenda. And that points to an aspect that I think is worth highlighting with regards to these human rights-based cases. And that's the role that other sources play in human rights litigation. And I won't go into detail today, but basically in determining the scope of the human rights obligations of the state in the context of climate change, or we also saw in the context of private corporations in the Shell case, the court draws on international climate change law and also best available science to determine what is required of the state to meet its obligations, particularly what is reasonable and appropriate in the context of climate change. And then just briefly, what is one of the key benefits of these types of cases? I think these human rights-based cases really speak to the core function of what the core function of courts, and Christina mentioned it in her introduction, that the kind of important role that courts play as the third arm of government, as sort of protectors of the Constitution. And these rights are normally protected. Most constitutions include fundamental rights. And so when these cases are brought, they're really asking the court to protect those rights without the perhaps the concern that the other arms of government have for being re-elected within 3 years. So we see that particularly in the German case, where the court looked beyond the kind of immediate term and said, well, the violation of rights that will occur after 2030, particularly for the youth plaintiffs, means that the government really must do more now. And I think that's something that we are not seeing governments take that sort of action. So it's really important that the courts step up in that regard. The challenges have already been pointed to, so I'll leave that for other speakers with standing, but we're also seeing huge progress in that regard as well. So I'll leave it there. Thank you.
Thank you. Thank you so much, Sarah. So I'm keen to bring Robert back in here, and I will ask Pilar to join in. So Robert, from a judge perspective, this human rights arguments, is it convincing? Is it not convincing? I mean, what has been your experience, or what do you think will happen when it comes to human rights arguments from the bench?
Well, I mean, I'm not sitting as a judge anymore, but I must say, looking at these cases from a judicial point of view, I've always been much happier to find a specific national legislative framework rather than looking at more general human rights conventions. They're obviously very important as underpinning. But I was interested that both the Irish court, the Supreme Court, and the French Conseil d'Etat, in the cases they had, were somewhat skeptical about the value of using the sort of human rights, particularly the European Convention, on it as a basis, because it wasn't sufficiently specific. I mean, I think in this country we have, as I said, we have our much more specific Climate Change Act. I've been interested in the extent to which other jurisdictions have been able to use the human rights, whether from the Constitution or generally. But I'd be surprised if an English court went that far. But it'll be very interesting to see what the European Court of Human Rights does with the cases currently before it, which are obviously a very important test of that.
Thank you very much, Robert. And again, bringing Pilar into this human rights dimension, I wonder whether not only your own comments on the question, but maybe from a Latin American perspective, the case law coming out from your region, what are your thoughts when it comes to human rights and climate change litigation?
Gracias, Francesco. Bueno, creo que los derechos humanos en Latinoamérica y particularmente en el marco de los litigios climáticos están cumpliendo un rol muy importante. Y particularmente me gustaría referirme a lo que es el derecho a un ambiente sano, que se enmarca dentro del concepto de la constitución ecológica. Esto en muchos países latinoamericanos como Ecuador, Bolivia, Colombia, y ahora en una discusión reciente en Chile, puesto que se está discutiendo una nueva constitución, hay una asamblea constituyente que va a empezar a trabajar muy pronto en esta nueva constitución, y el tema de la constitución ecológica está muy presente. Al respecto, me gustaría señalar cuál es el avance que, a mi juicio, ha tenido el desarrollo jurisprudencial en Latinoamérica a propósito del caso de la tala ilegal de la Amazonía colombiana, puesto que aquí se pueden destacar dos cuestiones muy importantes. La primera es la argumentación que dan las partes respecto de la vulneración de este derecho a un ambiente sano como consecuencia del aumento de gases de efecto invernadero, provocada en este caso por la disminución de la superficie de la selva de la Amazonía colombiana. Al respecto, también podemos destacar la relación de esta ampliación en la interpretación del contenido de este derecho en términos temporales y territoriales. La Corte Suprema colombiana señala que los intereses considerados en este caso no deben limitarse a la región específica de la jurisdicción habitual del tribunal y tampoco deben estar limitados a la generación actual. La Corte Suprema colombiana sostiene que la vulneración a un derecho al ambiente sano consagrado en la Constitución colombiana vulnera el derecho de los demandantes, de la población colombiana, de la población de todo el planeta, de las generaciones presentes y futuras. E incluso habla de las especies humanas y no humanas. Por ende, vemos acá un desarrollo jurisprudencial que tiende a ampliar el contenido de este derecho a un ambiente sano en el contexto del aumento de emisiones de gases de efecto invernadero.
Thank you so much, Pilar, and you clearly confirmed that this increasing interest towards human rights and climate change litigation is a global phenomenon, definitely not just a regional here in Europe. And I must say, I'm even more excited to be organizing a further event in the context of the Climate Change Litigation Initiative with you and with your university, where we'll expand on all of these matters. Now, there's so many interesting questions coming, so I will try to speed up a little bit in the last two questions, but these are two important questions that give you as big of a picture as possible in a webinar like this one. And actually, I'm going to keep Pilar on her toes, and I'm going to ask Pilar again a question. And this is looking at specific countries, and here, obviously, I'm thinking of Chile in particular, but for Pilar to mention what she wants, if she can share with us any recent developments in climate legislation, or maybe setting of targets, or maybe of NDCs, that you believe may have an impact on future climate change litigation. So Pilar, I'm asking you again to start this conversation on this question.
Gracias, Francesco. Bueno, yo en este punto quisiera referirme al rol que está jugando el Acuerdo de París y las obligaciones de los estados partes del acuerdo, consagrados en las respectivas compromisos nacionalmente determinados o NDC. Creo que en el caso colombiano al que me referí recién, o también en el caso noruego de la producción de petróleo, se menciona el Acuerdo de París como un fundamento en la demanda de las partes para sostener que las decisiones u omisiones de parte de las autoridades de esos países son incompatibles con los compromisos internacionales asumidas en materia de cambio climático. Y en este sentido, las partes plantean la necesidad de mantener una coherencia entre las decisiones políticas y normas internas con los compromisos internacionales. En ese sentido, es interesante ver que el compromiso internacional contenido en las respectivas NDC de los estados partes del Acuerdo de París termina transformándose en un estándar de actuación para la administración de los estados. Así, por ejemplo, en el caso colombiano, la NDC de Colombia indicaba como compromiso disminuir la tasa de deforestación a 0 en la Amazonía colombiana para el 2020, lo cual no habría sido respetado en razón de la tala ilegal que se produjo en ese país por la falta de fiscalización de las autoridades. Ahora, cabe mencionar, eso sí, que si bien el Acuerdo de París y las obligaciones asumidas en el marco de las NDC juegan un papel muy importante tanto en la argumentación de las partes y el razonamiento de los tribunales de justicia, la resolución de los casos también se fundamenta en el derecho nacional. Ya en el caso de Colombia existía una ley que se refería a la reducción de la deforestación. Era la ley 1753 del 2015. A su vez, me quisiera referir a un caso reciente chileno que falló la Corte Suprema confirmando la sentencia del Tribunal Ambiental de Santiago respecto a un proyecto minero que pretendía alargar el tiempo de la actividad y para ello solicitó una evaluación de impacto ambiental de la actividad que se extendía en el tiempo. En este caso, la Corte Suprema también se refiere al Acuerdo de París para señalar que esta evaluación de impacto ambiental del proyecto minero que afectaba las napas subterráneas de agua debía incorporar la variable de cambio climático en las modelaciones hidrológicas. Ahora, también la Corte en este caso, si bien se refiere al Acuerdo de París como fundamento de la resolución del caso, lo hace en concordancia con la regulación interna, que dice la Corte debe materializar en términos concretos la referida normativa internacional. Entonces, para concluir, parece importante el rol que está jugando el Acuerdo de París y las obligaciones que tienen los estados en la litigación climática, pero que esto debe ir acompañado de una normativa nacional que así lo ratifique.
Thank you very much, Pilar. Let me bring in first Michael and then Marie-Claire to this conversation. Pilar mentioned the Paris Agreement. And if there is one country that has done a U-turn when it comes to the Paris Agreement, obviously that has been the US with its new administration. So I wonder, Michael, from your own perspective, being in the US, following US climate policy, do you think this is going to change? Is this a development really worth keeping an eye on?
Mm-hmm. Thanks, Francesco. Well, that's a tricky question, because it really would take a crystal ball to be able to predict whether or not it sets in motion a different trajectory going forward, because anybody who remembers the history of climate policy domestically and internationally and the role of the United States in it knows that it's been a real pendulum. It's very cyclical. So whether it's Bill Clinton's administration, negotiating the Kyoto Protocol, signing up, George Bush Jr. then withdrawing, then we have Obama sort of participating, very instrumental in getting the Paris Agreement, then the next administration, Donald Trump, withdrawing again. And similarly, we have a lot of variation at the domestic level with domestic policy. For one thing, we do not have legislation. As I mentioned earlier, the last sort of best chance in 2009, 2010 failed, and conditions were much better then than they are now in terms of the majority, for instance, in the Senate and in the House of Representatives. And so we are stuck, for better for worse, with mostly executive action. And indeed, the NDC that President Biden presented to the world, if you like, during the recent Leaders Summit on Climate Change on Earth Day on April 22nd, is of course an important progression, but it is also purely an executive act, if you like, where the US pledges to reduce emissions by 50 to 52% below 2005 by 2030. So the risk is, of course, if we have a change in administration and also changes in Congress, that this may be overruled or indeed just repealed and replaced with something weaker. And I also want to add that, unfortunately, while there is prospects, of course, of litigation, say under human rights, if there's no legislation, but under other things such as human rights obligations, it's worth reminding ourselves that the composition of the judicial branch, and especially the Supreme Court of the United States, is also not terribly favorable. So, for instance, many refer to the Massachusetts versus EPA decision of 2007, which told the EPA that it has to make an endangerment. It didn't say it had to regulate greenhouse gases, but at least it has to make a finding about that. That was, for instance, still a court with a more favorable composition. Now we have 6 conservative judges, the recent replacement of Justice Ruth Bader Ginsburg with Amy Coney Barrett, whereas she has expressly said that she thinks climate science is unsettled and it's a political question that she won't comment on in her nomination. So I'm much more skeptical and much more concerned looking into the future, but I still think that for the international dynamics, negotiations, the look forward, it has been very important that the US administration now has kind of stepped back into the game.
Thank you very much, Michael. Marie-Claire, what are your thoughts on these NDC-related world and targets and everything?
Well, I've been looking at them, especially in terms of ways to be able to encourage investment, especially in highly climate vulnerable countries that are struggling, but are still bravely putting forward the most ambitious NDCs that they can't. But I think that in this particular context, with 2 minutes and 2 points, because I know Sarah will do me the favor of covering some of the RWE and other litigation, I will simply mention briefly that it is interesting to keep an eye on regional court decisions that take into account directors' duties And I've been pulled into this just recently because we founded a new center here in the University of Cambridge, the Hughes Hall Center for Climate Change Engagement, that assists through something called Chapter 0, the non-executive directors on corporate boards to ask some tough questions of their executives, and sends them climate science and climate law collected from across the university and with our colleagues, so that they can ask those questions in as useful a way as possible inside the board. And so there I would just point to two developments that I think are worth commenting on. The first one obviously is the regional court in Poznan in Poland with its August 2019 ruling in the case of Client Earth versus Enea, where indeed the Polish utilities authorization for the construction of a coal-fired power plant was called into question, and Enea's responsibilities, particularly in terms of the board members' fiduciary duties of due diligence and to ask in the best interests of companies and their shareholders, were called into question. And indeed, the court actually found that the financial risks posed by the construction of a new plant to shareholders, given lower priced renewable energy technologies, increasing carbon prices, and EU energy reforms that could affect state subsidies for coal power, needed to be taken into account and in some cases prevent that coal investment from going forward. And with that, I would point to the last development in my 2 minutes, which will make Robert Carnwath laugh, because of course it sounds like we're in advance of Glasgow COP26 promoting UK legislation. But I'd actually like to point to a policy initiative, and that is, of course, the Task Force on Climate-Related Financial Disclosure. And I do think that's a very interesting one to follow, because as we start to look much more carefully, and of course, the recommendation that corporates should disclose their climate-related financial risks alongside other financial and security risks was taken very, very seriously by many institutions in the financial world here in London. But it's also been supported by the EU high-level expert group on sustainable finance and even by the UK's Green Finance Task Force. So when we look at these types of policies, when we look at obsolete fossil fuels and the requirement on boards of directors to act in the best economic interest writ large of a company, including moving away from technologies that are simply no longer viable in a climate constrained world, I think there's a lot to explore there, and probably quite a bit more to keep an eye on and to watch. I can see Michael thinking furiously, because of course there are equivalent developments from that task force on climate-related financial disclosure in the US, in Paris, in Germany, and in other countries. So it's worth keeping an eye on and hopefully even seeing some movement in. Thank you, Francesco.
Thank you very much, Mary-Claire. And this is actually a good segue to the last question before we move on to the Q&A. And this is about countries that actually have strong climate legislation. And it's about countries being challenged to some extent because of that. So I'm going to ask Mary-Claire. So a bit like before, we finish with Mary-Claire, we start with Mary-Claire, this last question. Can strong climate legislation be prevented or protected by investors through international claims? And you already hinted to a case that is, to some extent, happening in the Netherlands. Yes, Mary-Claire.
Absolutely. In my view, the risks and global impacts of climate change are gaining in significance and priority throughout the world. And the majority of countries and enterprises are actually working to redirect investment flows toward more sustainable, low carbon development pathways. While the few outliers, and Michael referred to one, do face a rising tide of potentially costly litigation on climate change. But when I look at the role of investors, and I look in particular at how we can help to redirect that investment and to really reopen the world economy after the COVID-19 pandemic in a way that is more sustainable, I'm quite concerned and at the same time hopeful. The OECD has noted that to meet the targets set out in the global SDGs and to achieve the high international ambition of the Paris Agreement, further exponential increases are essential for investment in low carbon green growth, including climate smart projects and infrastructure, particularly in developing countries. And I'm going to ask the person who's moderating to try to find a way so that we're not forced to look into Francesco's earphone, if they can switch the screens around like they did earlier for Sarah and Michael. Then the other issue is essentially, well, what are the trends then in investment law decisions on matters pertaining to climate change, clean energy, and sustainable development? And when you look at those trends, and I've had occasion to do so recently, I find they're actually quite difficult to distill, not just because of the nature of international investment law, but also due to the lack of binding precedent in international investment arbitration. Still, we've got Jorge Vinuales and other colleagues pointing to 1% of the investment disputes with relevance to clean energy, moving up to 20% of the cases in just recent years. We've seen investment cases pleaded in front of human rights tribunals, such as the UCOS decision, which does actually point to a precautionary approach and taking into account a polluter pays principle. We've also seen, of course, a slew of cases in Spain where renewable energy investors took the Spanish government to court in order to ask for commitments on feed-in tariffs and subsidies to be respected rather than thrown out. So in that particular case and that whole set of cases, the Spanish government was being told, keep your green energy, keep your clean energy provisions and make them stronger and more effective, or you will be forced to pay compensation to investors who relied on them for solar and wind farms, for example. On the other side, we're seeing a new set now with Uniper versus the Netherlands or Westmoreland Mining Holdings versus Canada of litigation in 2021 and 2020, where investors are challenging the decisions of countries to pull out of coal. Yeah, so I think, yes, we can be hopeful. We can look at PV investors versus Romania with 44 photovoltaic power plants challenging the government under the Energy Charter Treaty, or we can look at decisions like Fraser Solar versus Lesotho, looking at contracts for solar water heating. And the attempts of the investors, even in 2021, to use investment litigation to push forward and protect the gains they've made in legislation. In the end, my question mark becomes, well, is investment law a sword or a shield in this area? It will obviously, by good lawyers, be used to attack changes that make climate change unfriendly investments less viable economically if an investor has put their shirt in and is about to lose it. But they might also be used to protect gains in climate legislation, where an investor is in the renewable energy market and may even serve to tip the scale toward that investment that is required under the Paris Agreement. What we've been able to see, of course, is that in each dispute, there's a need to make a sound case. And that is what is actually going to carry the day. So I would actually encourage more arbitrations in this area. And I would encourage arbitrations that take special account of countries' commitments under the Paris Agreement. In a carbon constrained world, what we need is Article 2.1c, more investment, more financial flows toward renewable energy, and anything that we can do to make the global investment landscape more secure and more stable for those often small renewable energy companies to be able to make their investments, not just north-south, but increasingly south-south, is actually very worthwhile. I'll add a last point in 2 seconds, which is simply to flag that states are aware of this, and they're writing this into some of their bilateral investment treaties. And even in the case of the Canada-EU trade agreement, some of the provisions to encourage trade and investment in renewable energy and in eco-innovations. So I think that there's more to be done here, but what we have to take away is that it can be both. It's a sword and a shield. And when you look at a claimant, you need to think about the claimant being not just the oil company that's about to lose its shirt, but also the tiny solar investment company that is about to lose its shirt. And think carefully, for whom is the law going to be more important as a protection? Is the oil company going to care? Or is that small solar or wind power generator really going to care? And if your answer to that question is the second one, then I think that we have a duty as lawyers to do a little more work in this area. Thank you.
Thank you very much, Marie Claire. I'm going to challenge Michael and Sarah to be very brief here so that we get some more time for the Q&A. Obviously, this opens a wide array of super interesting, slightly different kind of litigation, almost litigation to prevent some kinds, climate change mitigation. But Sarah, let's start with you. Do you have just a quick pointer in reaction to Marie-Claire's point?
Yes, and I think Marie-Claire indicated also, she pointed to the RWE case that's underway, and I can speak to that in the context of the Netherlands. So as many of you will be aware, the Urgenda case was brought against the government and led to orders that the government had to reduce its emissions. And that led the Dutch government in due course to make widespread changes to its climate policy, including closing coal-fired power plants and looking towards reducing its capacity, coal capacity. And this all in the context of the state's decision to phase out coal by 2030. So in a slightly more negative perhaps frame than Marie-Claire has presented, this case that's been brought by RWE really points to the risk associated with investor-state dispute resolution. So what we have seen earlier this year is RWE, a German utilities company, suing the Dutch government for its decision to phase out coal by 2030. And it is doing so on the basis of the Energy Charter Treaty, which allows private investors to bring a claim seeking damages for lost earnings. And I think it pays to keep in mind that this claim that's been brought by RWE for 1.4 billion euros is essentially in response to the Dutch government seeking to meet its human rights obligations under the law. And we have already seen another case being brought by Uniper just in April, also against the Dutch government, also on the basis of the decision to phase out coal. So here we really see a real tension arising between ISDS and human rights protection. And I think it's really important that we turn our attention to it. Because at this stage in the piece, it's really critical that that governments spend all the money that they have to put to the task of the Great Transition to protecting human rights. And I'll just quickly flag also that it's about time that it's I think important that private companies like RWE start to take responsibility for their own contribution to climate change and also meet their own obligations under human rights law. And that we have seen in the recent Shell decision in The Hague, where the court is holding Shell accountable for its human rights obligations. And so hopefully we see more of that, and that's, I think, a great cause for celebration. I'll leave it there.
Thank you, Sarah. Thank you, Sarah. So Michael has very kindly renounced to his possibility to comment on this to give more time to the audience. So thank you very much, Michael, for that. This has been a roller coaster. I have enjoyed it tremendously, learned a lot, and really got a lot of insights. And I think I must not be the only one because there's a lot of questions, really a lot of questions. I will ask each one of you one question. And if we have time, I may be able to ask a second one. But before I do that, I do want to thank my colleague, Amelia Burnett, who's a skilled PhD researcher and C2LI legal analyst, for filtering more than 30 questions to making them just 5, one for each. So thank you very much, Amelia, for that. So without further ado, I'm going to start with Robert. The question for Robert comes from Daniel Orona. And the question is the following. What role could specific legislation play in addressing the issue of the evidence before domestic courts? Can you answer that question, Robert?
Well, it's a general question. I mean, obviously, one could have specific legislation to deal with particular evidentiary problems, but I'm not, in fact, aware that there are major evidentiary problems, certainly as far as the UK courts are concerned. I think when one has litigation within judicial review, one brings forward the evidence one needs, either expert or general, in the normal way. And of course, a key feature will be the evidence of the views of the Climate Change Committee. So I'm not at the moment, I may be missing some important point here, but I'm not at the moment conscious of any particular gaps in the problem of evidence which need to be filled, but others may have a different view on that.
I'll get potentially to other people later if they want to comment further. I do think to some extent the fact that courts feel more comfortable with evidence related to climate change means that climate change litigation has matured a lot, and the climate change law has matured a lot. Back in the days, evidence was a big hurdle when it came to litigation. So maybe also that's something to say there. But let me move on to Michael. For Michael, we have a question from Akhtar Uz-Zaman. A short question, but an important one, especially from a legal/political perspective. So the question is the following. As NDCs reflect political outcomes in many cases, can NDCs be judicially enforceable? Michael.
Thanks, Francesco. It's a great question, and one that international lawyers have spent much time discussing. Unfortunately, I think the answer is short, but it's not. It's the opposite of yes, but it's a no, but. So as such, they are not enforceable. That is very evident that they do not create international obligations as a procedural one to submit NDCs. And there's some debate about how they have to progress NDC after NDC, etc., under the Paris Agreement. But as such, again, they don't create international legal obligations. However, many NDCs reflect targets and other commitments that are legislated domestically in statutory legislation or some other form of regulation, and that indeed could be grounds for litigation, as we heard in various interventions during today's panel. And also, whatever countries commit to individually and collectively will certainly play a role in interpreting, where the status, where we stand in terms of understanding climate change, action against climate change, and the obligations of countries, and how we interpret, for instance, human rights obligations.
Yeah, thank you very much, Michael. And I have a bit of a curiosity to see also the next NDCs, the idea of ratcheting, I hate that word, ratcheting up NDCs, and the extent to which all this floods of climate litigation will have an impact, hopefully positive, on getting better NDCs, more ambitious NDCs. Thanks, Michael. We have a third question. This is for Sarah. And the question is from Kathleen Zagara. The question is the following. Is it possible to constitutionalize the principle of climate justice in countries as a human right through climate litigation? Sarah, can I kindly ask you to take this question, please?
Yes, so I think the answer is probably yes. We are seeing claims being brought that kind of are edging towards that sort of recognition of usually not climate justice, but the right to a stable climate. We've seen Professor Boyd has given a lot of support for that in his Safe Climate report, saying that a safe climate really is an essential foundational right to the enjoyment of all other human rights. So I think the first step probably is a further recognition of a right to a healthy environment. We're seeing that go forward and backwards. In Ireland, there were steps forward, but then steps backwards in the Supreme Court judgment. But I think as that right becomes more widely recognized and the Human Rights Council's taking action, hopefully, in that direction, there's a really strong movement towards that recognition of the right. Then the next step will be that recognition of a right to a safe climate, which hopefully has built in its sort of climate justice aspects of equity and common but differentiated responsibilities. But yeah, I think that's definitely where we've already seen litigators pushing the courts to kind of extend the rights that are already recognized in constitutions to make them real and practical, and as the ECHR says, a living instrument to make sure that there is effective protection. And so if not expressly, We're very much hoping that we'll see, in effect, a recognition of the right to a safe climate and built into that justice aspects. I think I'll leave it at that for now.
Thank you very much, Sarah. We have two questions and then hopefully we can get a few more in. So this is for Pilar. It comes from Susan and Samuel. So the question is the following, Pilar. Can the efficiency of climate legislations in Global South be improved, strengthened through climate litigation in the Global North? So Pilar, what is your take on this cross-fertilization of litigation, if you want? Pilar.
No sé si se trata del norte y del sur, porque justamente la realidad del norte y del sur son muy distintas. Y yo diría que hoy en día la influencia del sur en el sur es muy relevante. Estamos frente a una discusión constitucional en Chile, donde se están discutiendo los derechos de la naturaleza, el derecho de acceso humano al agua, el derecho de las generaciones futuras, y para ello se toma como ejemplo o como experiencia la experiencia del sur, de Latinoamérica. Entonces, si bien uno puede observar que las tendencias jurisprudenciales y los avances legislativos del norte pueden ser una referencia, también lo son las del sur. Ahora, yo destacaría como principal elemento en la legislación nacional el derecho internacional. El derecho internacional sí marca una pauta, una orientación, y ha sido determinante en el desarrollo de la legislación nacional en Chile, y yo diría en Latinoamérica y quizás en el mundo. Tanto la Ley de Bases Generales del Medio Ambiente en Chile, como hoy día el proyecto de ley marco de cambio climático, están absolutamente determinadas por el derecho internacional. Entonces ahí sí yo veo un valor de todos los tratados y acuerdos internacionales en la definición de legislaciones más, con mucho más contenido, con contenido más duro, de derecho duro, para lo que viene y lo que sigue. Gracias.
Thank you very much, Pilar. And I, like you, I really don't like the label Global North, Global South when it comes to climate change litigation. I think the world is much more varied than that. So I'm happy you highlighted that, and I see Mary Claire smiling. So I know I'm not the only one here thinking like that. So actually, let's go to Mary Claire with one last question to the five of you, and then I hope to have one more question for one lucky person. So the question for Mary Claire is the following, and it's about the Shell decision. I'm curious to hear what you have about this question. What grounds of appeal do you expect that Shell might pursue? And if Shell wins the appeal, what is next for legislation or litigation? Because let's remember that the decision that you see op-eds on every single journal of the world is just the district court. So there's still two possible appeals for Shell. Mary Claire, what do you think?
Yeah, that's an interesting question. And when I consider it, I think they'll use the same grounds of appeal that other companies have used in these situations over the last 20 years. I think what is most interesting to me here, and this is possibly a bit of a strange or unique perspective, at least for us since '92 in the Earth Summit with the adoption of the Framework Convention on Climate Change, and since 2005, when in Montreal at McGill, we hosted the first Climate Law and Governance Day, just as the Kyoto Protocol entered into force. And countries started saying, what kind of laws are we going to need? At that time, they were trying to take it seriously. What kind of laws are we going to need to be able to regulate the behavior of companies and corporate actors? And I saw a group of climate litigators in even back in Montreal in 2005 when we were hosting Climate Law and Governance Day, coming together and starting to share ideas. And I thought, this is actually very, very healthy for our international community. And I'm building on what Pilar was saying, but also coming to my answer to your question. They were doing the same kind of collaboration and sharing of ideas and sharing of arguments and expertise that our colleagues in the business world have been doing as part of their regulatory strategy and their litigation strategy already for decades, as part of just doing business. And what I've seen since 2005 all the way through to Madrid just a little while ago was those litigators coming together and starting to say, all right, we need to work together if we're going to learn lessons from tobacco litigation and advance cases that have a hope of advancing the law. They are in the end actually showing a little bit of even trust in the courts or respect for the courts by wanting to see the courts themselves take on these issues and answer in a way that is for the good of society. Now, I don't have any illusions that companies shouldn't and couldn't and aren't doing the same. But what I'm more excited by, to be honest, isn't really so much where Shell is going to settle or not settle and what Shell is going to argue in this particular case. It's more what is happening in the investor community and what is happening in the SDG community with companies that are taking on a purpose-led approach and are saying, we can do business differently. And when I look at all of the different large oil and gas companies out there, and I remember my conversations in the Hague COP with Suncor and some of the other actors who had sold off their oil sands investments and then had to reinvest in them when the governments didn't follow the promises they'd made. I can't help but wonder, among our oil and gas companies, which ones are going to start taking seriously their renewable energy commitments and change their business operations to reflect what they're hearing from courts, what they're hearing increasingly from governments, and which ones are going to be the bottom feeders that we have to keep, raising these issues with. And that's where I'm actually more excited. I'm definitely interested in what Roger and the others are doing on climate litigation with Shell. And I also have a fair bit of sympathy for some of my colleagues in the business community who are trying to make changes in their operations and are running into serious obstacles. And I'm wondering whether there's actually something more to do here in terms of helping companies, including Shell, that have tried to move in a different direction and have faced internal and shareholder pushback and are still trying to falteringly move in a different direction. Because I think those larger changes that they make in their operations, not just Shell, but British Petroleum and many of the others, could actually end up being part of the solution. And litigation helps them get there. It helps strengthen those internal voices that are asking for us to take seriously our commitments. I sit on the board of some companies, admittedly not in the oil and gas sort of community, and I can see them adopting the Sustainable Development Goals as their purpose as a company. And I find that very exciting. So before I start advising litigants on what they should or shouldn't be using as strategies in an individual case, I would actually take sort of 6 steps back and say, are we sure that the purpose of a corporate entity is still the same as we think it should be, maximization of shareholder value, or can we start taking into account some of the environmental and social imperatives embodied in the SDGs? Thank you.
Thank you very much, Marie-Claire. Sorry to interrupt. So if Christina gives me the possibility, just one more very quick question, and then I'll give you the floor, Christina. So the lucky speaker who gets a second question is, drum roll, is our colleague Pilar. So I hope you don't mind, Pilar, asking me this last question. I find it really interesting and intriguing. And the question is the following. This comes from Mario Delgado. And the question is, what do you think about rights of nature as a legal avenue for climate litigation? And let me just 2 seconds expand on that. We're talking about the interplay between legislation and litigation. So in some countries, rights of nature is not just an abstract theory, it's actually put into legislation. So I wonder, Pilar, if you can just, I know it's challenging, but in a minute, just say what your initial thoughts are about this.
Bien, en un minuto. Está bien, lo voy a intentar. Yo creo que los derechos de la naturaleza, en primer lugar, plantean una nueva relación de la humanidad con su entorno. Y yo destacaría eso en primer lugar, porque donde se han consagrado los derechos de la naturaleza, también se ha reconocido una nueva relación del ser humano con esta. Es decir, que no hay una relación de supremacía ni de hegemonía del ser humano sobre su entorno. Entonces yo destacaría en primer lugar esa concepción que corresponde a una visión más global respecto del derecho en sí mismo. Luego, para la litigación, lógicamente que el reconocimiento de derechos de la naturaleza favorece una mayor protección del medio ambiente, sin perjuicio de lo cual creo que hay que tener dos prevenciones. La primera es que reconocer los derechos de la naturaleza no resuelve todo. En Chile se está discutiendo esto como quizás un paradigma de la constitución ecológica, pero eso no resuelve todo el problema. Y lo segundo es que la implementación de los derechos de la naturaleza es compleja. Es compleja y a propósito hay varios casos colombianos en que se reconocen derechos de un río, por ejemplo, y en ese caso el problema es que muchas veces se designa la representación de los intereses de ese río al Estado. Y eso no es lo que consideran las comunidades como correcto, porque las comunidades de ese río consideran que el río es parte de un interés colectivo de la comunidad, que no puede ser representado por el Estado, que es una identidad distinta, que no representa justamente estos intereses de las comunidades que viven en los ríos. Entonces, quisiera a través de esto explicar que creo que es un avance en una nueva concepción y paradigma que es importante, pero queda por resolver muchos otros aspectos, porque no podemos tomar los derechos de la naturaleza de manera aislada. Corresponden a una concepción más amplia de una visión de nuestra relación con el entorno.
Thank you so much, Pilar, and I obviously understand it's very difficult in 1 minute, so thank you for trying. So before I give the floor to Christina, let me just thank Emily Gaskin at the IUCN World Commission on Environmental Law for helping us throughout this webinar, before, during, and after. To Amelia Burnett again for helping us out in the questions, all the team at SCELG and C2LI working with me on climate change litigation. And a huge thanks to Christina for inviting me to moderate this session. I enjoyed it. I hoped people in the audience also enjoyed it. And a big thanks to all of you who posed questions. We'll discuss with Christina and Emily how we can capture all these questions and maybe share them in some way or another, because there's a lot in there. There's really a lot. So thanks to every single one of you, to the 5 speakers. Thank you so, so much. And I now give the floor to Christina to conclude the session.
Thank you so much, Francesco, for masterfully chairing this interesting and intricate discussion. It's not easy. There's so much in it, so many aspects, and I thank you very, very much for doing it the way you did, engaging everyone, engaging the audience. But thank you most of all to the experts, to Pilar, to Marie-Claire, to Sarah, to Michael, and Robert, for taking your time with us today and engaging in this discussion. It's an important one. It's just the tip of the iceberg, really. I think we all could feel there's much more to it, which we would like to explore. And I do hope that the audience was engaged as well. We certainly could see it from the many excellent questions we received, and we will try to save them. Emily is in the back here, and provide the speakers with a question. Hopefully you can answer them maybe by email or other means. So thank you very, very much to the speakers and to the audience for your time and your energy. Emily, thank you so much for making this work. Many, many thanks to the interpreters, and as well to Amelia for sorting out the questions. Before we finish, I just wanted to mention that the IUCN World Commission on Environmental Law in its climate change specialist group is actually conducting one of its projects on climate litigation. Sarah was so humble not to mention it, but Sarah, together with Margareta Weverenke Singh, are the leads of that project, and it's titled Fighting Climate Change. a best practice guide for judges and courts. And what Sarah and Margareta have done is to go through the currently available cases, and it's a moving goalpost because there's so many coming forward, analyzing what kind of arguments have been put forward, how were they received by the courts, how successful were they, how effectively did they lead to changes, to legislative changes or political changes in the respective countries. And we're looking forward to launching this project also at COP26 in Glasgow. So with all that, thank you so much for your time and your expert views today. And hopefully we'll see you tomorrow. As I mentioned, the next webinar is tomorrow at 5 p.m. CET, and we're looking at effective strategies for environmental compliance and enforcement. With that, stay safe, stay well, and see you soon. Bye-bye.